Hi, everyone. I'm really delighted to be the interlocutor this afternoon with James Grimmelmann. But I want to start by thanking the organizers of the event, Joan, Josh, and Dave. It's been really exciting to see them put together this program and find ways to kind of really advance a lot of the discussion that's been happening over the past couple of years. I also wanted to note that my very first academic event was actually at DIMACS. So it was my first semester as a grad student. And it was a similar attempt to kind of bring together folks from law and policy and computer science. And so there's a long history at DIMACS that I actually credit with setting some of the direction of my own research. And so it's really nice to have an opportunity to come back and discuss a number of the same themes, although much, much more mature than they were when we were discussing them probably 10 years ago. And finally, I want to say that it's just delightful to be able to serve as the interviewer with James. James really needs no introduction in this crowd. He straddles these worlds. He has for a very long time. In fact, he's inspired a lot of us to try to do the kind of work that he's been able to do for more than a decade now. But today's conversation will focus on this new project that James has. It's a book project by the name of CPU Esquire, although in my head I say CPU ESQ. What is the right pronunciation? What is the right way of saying it, James?
They're both fine. The title is a pun that's also designed to be typesettable in a nice 2x3 block.
And if you know James, you know that this is also an important criterion for the project he's working on. So that's good to hear. I'll just open with like one very brief remark before inviting James to kind of give us an introduction to the project. And as I mentioned, I think this conversation has been ongoing now for a number of years. And I think there's a kind of familiar point of tension in these discussions. So on the one hand, people who come from a more computational background often want to figure out how to use the precision and rigor of computer science to try to give some technical force to principles and rules in law. And so a fair amount of work is how do you translate these ideas in law into something that can be kind of specified very precisely in code. And then in turn, lawyers and folks in the kind of broader policy world struggling to actually deliver the kind of precision maybe that folks in computer science expect or demand. And that maybe when they do offer some of these more precise technical definitions or instantiations of some of these legal principles, that they may not be a perfect, may not be perfect correspondence with what the law actually is intending to do, or maybe even what the function of law is more generally. And I think James's project sort of sits exactly here in the middle of this tension, trying to offer us a different way of thinking about this, but not actually in the way that you might expect. In my reading of James's kind of outline of the book and from prior discussion, my sense is that James is trying to encourage us to think critically about the function both of code and the law at the same time, and to not kind of just see one as being, the clearer way of advancing the field. And so maybe to start off with, James, I invite you both to give us maybe a kind of general introduction to the project, but also to kind of reflect on how this tension in particular motivates the work.
Yeah, so I came into law and tech policy from CS in the early 2000s. I went to law school with the goal of working on tech policy. And at the time, the zeitgeist was very much the working out the implications of code as law. Lessig's slogan for this movement you really see in the 90s and 2000s that says you can do regulation with law and the powers of the state, or you have this technical power to limit behavior in online spaces. So DRM limits what you can do with a copyrighted work, or the rules of a virtual world limit how players can interact. And you could just code your legal rules into software. And that transition is very liberating and very threatening. And so a lot of work has gone into trying to figure out what changes when you have that. Do you get perfect enforcement? What values are preserved and what values are lost when you translate like that? Does it make the state stronger or weaker? And there's a whole really exciting, extensive body of scholarship building out of that idea. And the idea for this project is one that I've been wrestling with for a while, that goes in some ways back to the part of computer science that I came to law from, which was programming languages. That was what I worked on as an undergraduate. I worked at Microsoft and a compiler group, And I've always really loved the linguistic aspect of how we tell computers to do things. And I've been playing for years with the sense that legal language has a lot in common with programming languages, that lawyers and programmers have a set of similar habits of thought, that technical training served me really well in law school. And the way of breaking down a legal test into its elements felt very familiar. And people who are drafting laws worry about precision and rigor. And the idea is like, oh, cross references here feel like pointers. There's this sense that there's a similar linguistic level. Well, these two ideas came together in this idea that, well, actually, maybe what programming does is it removes the ambiguity, it removes all of the natural language, human imperfection from how we express ourselves. Programming computer forces you to express yourself really rigorously, really precisely. And maybe that's the virtue that lawyers are striving after. Maybe that's part of what makes computers attractive as a substitute for legal enforcement, is eliminating that ambiguity and discretion. And I came across a really remarkable quote when I was starting to work on the book earlier this year, that's from an opinion by a Court of Appeals judge who writes, language codified by lawmakers is like language coded by programmers. A computer programmer may write faulty code, but the code will perform precisely as written, regardless of what the programmer anticipated. Courts, no less than computers, are bound by what was typed and also by what was mistyped. So the book is just really an extended exploration of that metaphor, that legal texts and software are very similar, and that legal law language could be, should be, can it be more like software. And the book is an exploration of how it can and how it can't.
Thanks, James. Sorry, it took me a moment there to unmute. I would love for you to kind of also give us a bit more detail for this intuition that there's a kind of interesting similarity between the way we use natural language and law and the language we use when we code. And so though I can see the affinity, and I expect that many of the people who are here in part because they've long understood there to be this interesting alignment between computer science and law. What might be a novel idea or a little bit more difficult to grasp immediately is, in what way can we think of coding as having similar properties to natural language, when in fact, this is by design meant to be much more formal, much more precise. So could you kind of give us a bit more of a sense for how to think about coding with the same kind of linguistic perspective?
Sure. So one of the things that I get from legal theory is people who've thought about philosophy of law have thought a lot about how philosophy of language plays into it. And this one really fruitful idea is the idea of speech acts, that there are certain things we perform simply by saying them. So if I say, the classic, if I hereby name this ship the Britannia, then there's something about the act of saying that actually makes the ship's name the Britannia. And law is characteristically filled with speech acts, that a contract becomes legally enforceable when the parties put their names to it and adopt its language as their own. Statutes, wills, regulations, all these things, verdicts, are all made, they do things in the world when some people say words in the right way. And from that perspective, that's what programming is. We think of ourselves as programming in things that look like languages. We call them programming languages, and you write the right keywords in the right order, and you enter them into a computer in the right way, and the computer does something. It makes an airplane fly, it makes a robot pick things up, it changes bank account balances. So there's something very similar in that force of doing things by using language in the right way. And that lets you look at what the vocabulary are, what the conditions under which you can use it, and how do you interpret the language people have used to conclude what its effects are going to be. That's the piece of legal theory that I think explains how programming and law are similar.
And I think so this idea that the right arrangement of the words has material effects in the world. Sorry, I said the right arrangement of words has material effects in the world makes a lot of sense in the legal context, right? So the example that I often think of from speech act theory is, when you say "I do" in a wedding, right? Like it's the kind of enunciation of these words which actually has material effects. And I likewise understand that when we arrange words a particular way, we can get the computer to do certain operations that have material effects as well. What's a little less obvious to me is how there's a similar correspondence around kind of like linguistic ambiguity, or the way in which like the choice of words invites subjective interpretation, right? So my sense is that law and the practice of law is full of trying to parse the meaning of words, contests over the correct interpretation, and so on. Which feels not exactly how things work in software, at least not intuitively. So is there a way to kind of continue this analogy? How do we actually think of a similar property with things that are often thought of as being very precise, very concrete in programming, for example?
So one way to comment this is that natural language is bottom-up. Natural language is whatever people use it as. That if somebody invents a new word, other people use it, it becomes a word. There was a time when WYD was not a word and no one knew it. LOL. These were non-words. But now, thanks to texting, people know what these are and use them as words. They've become words. There's no authorization from a dictionary or a language academy that makes them into the part of the language. It's just how people use it. And the conventions of the language are whatever people agree on. With a programming language, it's a kind of formal language. The connection here between programming languages and formal logical languages is very strong. And those are stipulated. You get a top-down definition, and the definition tells you what the syntax and the semantics of every expression in that language are. So you can, from that, say, this is how this language behaves. I have a formal specification for it, which tells me totally what it means. Hopefully no ambiguity there. Oh, and also I have a physical implementation of it. I actually have a computer that does it, which means I don't even need to be present myself to conclude that it means this according to the specification. I can just hit enter, watch it run, and it will spit out the correct result. So that seems to be a form of language with no ambiguity from the specification and from the physical realization.
And yet my understanding of the project is that you want to kind of challenge this idea. That while this feels like a very natural way to understand what computers are doing, that there are all sorts of reasons why this is probably not the correct understanding. And so again, I want to invite you maybe to help us understand the ways in which, according to the argument you're developing in the book, we should be skeptical of that argument.
I don't want to undersell it, which is there is a really strong degree of determinacy. You do run a computer, it does spit out a result. It's almost always the one that you'd expect according to the specification and the physical implementation. But that's not because it's not social. So natural language is incredibly social. The meanings of words are what people have agreed upon when they use them. And you have to find out what they mean by looking to how people in a community use them. So it's negotiated among people, and if there were no people, there would be no language to have a meaning. And the basic argument of the book is that computers are in fact the same way. That when we agree on the specification of a language, or we say that this is actually a C compiler, and this program here implements the C programming language, that's a kind of social agreement. And if we disagreed or we changed our mind about it, the semantics of the programs in that language would change. This happens every time you have a version upgrade. So that Python 3.7.3 is a different language than Python 3.7.2. There are programs that runs on differently. And if you just say Python, you're not actually specifying which of the ones you mean. People could have legitimate disagreements about it. So lots of arguments about language standards, about APIs, about is that a feature or a bug in programming, are actually very similar to legal arguments over, is this a correct application of the statute, or was it not meant to be used that way? Are you interpreting the words of this contract correctly, or does it actually mean something different than one of the parties expected?
The debugging example I found very clarifying, and it relates to a comment you made
Daddy,
at the very,
look! Daddy, look!
at the very start of
Daddy, look!
Yes, they just stick together. It's magnetic. Yeah. So go ahead.
Sorry, yes, let me try to quickly get this thought out. So you know, this judge who was sort of kind of drawing a parallel between the way that judges might be expected to understand the law and the way that computers are meant to execute code. And here, you know, it kind of raises this question around the difference between intentions and what is actually kind of committed to language. You know, what I found particularly interesting about this is that there might be a difference between what the programmer intends and what the program itself actually does. And that debugging is a clear case where that is apparent, right? Where the software is not working as intended. And in fact, the ability for other people, other programmers.
So there's a long-running debate in legal interpretation about what the goal of interpretation is and how to do it. And, you know, very broadly speaking, you could divide it into people who believe that intention is controlling, and the interpretation is to find the intention of the lawmaker or the contracting party. And the people who are textualists who think that it doesn't matter what the person subjectively intended, it only matters what's on the page, and those words control. So when I quoted the language from Judge Willett at the beginning, that's a strong textualist view. It's arguing we should be committed to only what's on the page, and intentions don't matter. And he's holding up computers as an example of that, where the computer runs even if the programmer thought something different. Well, we could call this, you know, we could say that's, yes, that's how computers work. But people would call that a bug. And many programmers reading a buggy program will say, well, yes, it runs, but it's broken. And therefore, yes, we should fix it for this person. So if you look at this in jurisprudential terms, it's a debate about what the role of judges are. Should judges be like computers who are faithfully executing whatever legal program they've been given to? And their job is to spit out the result, whatever was literally written down, however unlikely. Or are they more like fellow programmers who are cooperating in the enterprise of crafting law, and it's their job to debug certain kinds of obvious mistakes? They shouldn't obviously rewrite the program spec. They shouldn't turn the legal equivalent of a word processor into a web browser, but they should be entitled to go in and fix things when they find there's a bug and it doesn't match the specification, the goals of the legal language.
And to me, this also seemed like a point about the kind of social conventions that are embedded within programming, right? So for someone to be able to kind of debug someone else's code, it also requires like some intuitions about like what the other person wanted, right? To be able to look at this and be able to kind of sort out, well, I kind of can understand where this is going, maybe even without talking to the person who originally programmed it. And so, you know, this capacity to maybe reason about intentions, even in the absence of like the person who wrote it, to me also sort of emphasizes this idea that there is all sorts of social convention that supports the development of code. So I saw this as being a kind of clarifying point in both regards, both with respect to, you know, this kind of parallel you were just drawing, but also to kind of point out that there's a tremendous amount of sociality built into the way we actually develop software.
That we need to have a, you know, it's very hard to understand programming without understanding how people code together. And that you have practices like documentation and organization of files and creation of APIs. Yeah, and partly there for the programmer's own convenience, but in enormous part, they are there to enable effective collaboration among people by getting their understandings of functionality and goals to converge enough for them to use the program successfully together. If you're making an API, you're basically making a way of collaborating with people you've never met, which means you're communicating to them how to communicate with your program in a way that enables both parts to work together.
And I mean, I'd be curious. I mean, do you think it would be useful to spend some time also now talking about this distinction you draw between kind of programmer, and I'm going to forget the last one. Different kinds.
Yeah, I'll give my taxonomy of meaning.
Yeah.
So one of the lessons of interpretation is that there's no one meaning to anything. That lawyers are quite comfortable talking about the ordinary meaning of a statutory provision versus literal meaning. And you can multiply the number of different ways to interpret something. I think for programs and software, you can really tease out four different types of meaning that are all useful in different contexts. So one of them, the most obvious, is what I call program meaning. It's literally what the program does when you run it. And you have to make some idealizations here because the computer could be faulty, it could be hit by cosmic ray. So what a program does when it's executed on a computer that's functioning correctly. And basically, whatever it does, it is. If it has a syntax error, it has no meaning. Then there's what I'm calling programmer meaning, which is a slightly relaxed version of that. Basically fixing obvious mistakes. Somebody who reads a program with a small syntax error that means it won't compile will nonetheless be able to look at it and say, this program should have this functionality. It has some bugs, I know, but I'm going to mentally correct for them, and I can expect that the program will do X, Y, and Z. Then you have the perspective taken by users, and the users don't have access to the source. They just see what the program does. So if you think of an MP3 as a program for producing music, then to them, the meaning is the sounds it produces. Or you can have plenty of programs that produce messages or animations, and the user experiences those, and that's a different level of meaning than what's in the source. And then finally, I have what I call incidental meaning, which is comments, documentation around the program, variable names, things that don't make any difference to the functional execution of what it does, but nonetheless travel along with the text of the program that tell a programmer how it works. And often this incidental meaning is fun and interesting. There are lots of wonderful ways to play with it. The obfuscated C contest, where you have a program to calculate pi in the shape of a circle. That's an incidental meaning that's not related to its function, but it's fun to play with. And I think you really need all four to get at the legal ways that we think about software.
Yeah, so I think it would be great to hear how this framework sort of cashes out in some particular legal settings, right? So, I mean, your prior work has focused considerably on IP, and I know that part of the book will also go through a number of different IP cases. So I wonder if we can maybe walk through at least one of them, sort of using this framework that you've just laid out for us.
Sure, let's let me talk about copyright, because software copyright is an always controversial topic. It's at the Supreme Court now with Google versus Oracle, and it's an area where I think you can't get an answer for what the law should be, but you can clarify the discussion a bit with these concepts. So one way of thinking about this is that copyright has always protected expressive works. When you are expressing something, from the author's creative vision to an audience. And that's easiest to cash out for user meaning. Whatever the user sees when they are running a program, that could potentially be expressive. So programs that produce original animations of simulated fireworks. Well, if you create a bright, colorful display that's synchronized to a rhythm, yeah, it's expressive. You're just using the code as a medium to express something the same way that you use film stock or paper. That's easy to protect. That's copyright. And we've traditionally had this attitude that what's functional, the workings of a machine, the method for mixing paint, a method of doing bookkeeping, things that actually produce a useful result, that's not copyrightable. That's for patent, if anything, but you don't have copyright protection for those. So that's program meaning. Program meaning isn't protectable except insofar as it produces user meaning. But there are things that go into the code that are not required by its functionality. Those are your comments, obviously, but also choices about organization that don't have a direct payout in terms of how it does what it does. And that's what's copyrightable in the design of a program. So you could have variable name protection for just copied your source code literally, the exact names of your functions. Some of those details could be copyrightable even though they don't contribute to the program meaning. And I think that that's the kind of argument that lets you see what could be copyrightable in the Java sources or the Java APIs, and helps clarify how you can have a copyright there while saying what the limit should be to keep it clear of the functionality.
Thanks, James. So this is a really clear example of how this distinction allows us to then kind of draw some meaningful lines where I think certainly people have wondered, like, where is the boundary here? I'm curious too if we can think about how this might play out not just in the area of IP, but in other areas as well. And so I know that you have some interest in thinking about these same questions and sort of applying a similar framework in other areas of law. So to kind of bring in some stuff that I've been working on, like in instances that involve criminal law or administrative law or discrimination law, or these other areas which have become sort of hot topics for the past few years within the kind of CS and law area. How might the same framework help kind of adjudicate some of these questions too?
Sure. Let me give an example from criminal law, Computer Fraud and Abuse Act, and unauthorized use of a computer. So in a lot of cases, what's authorized to do with a computer is only ever expressed technically. You don't get a clear, explicit statement of you can do X, Y, and Z. No, you're expected to know just from its functionality that you're not supposed to use this web server to install arbitrary code. How do you know that? It had to have been communicated by the software somehow. And so you need a theory of what software communicates to its users in order to understand why a user is supposed to know that, no, you can't use this server to boot the server it's running on.
And in your framework, this would be an instance of programmer meaning, is that right?
So it's an instance of what the user would understand the program meaning to be. What would a reasonable user who sees this interface have understood actually the programmer meaning to be? Because this is a case where the program meaning, what it allows you to do, install your own code, and the programmer meaning, what was intended to let you not do that, diverge. And a reasonable user would see that there's a divergence there and understood they weren't expected to be allowed to do what they did.
I see. That's very clarifying. So the idea here would be something like, it's precisely because you can do something that is, not the intention of the original programmer, but that the program actually allows, is exactly why this distinction then ends up being particularly helpful. Got it.
Yeah, and if you didn't have that distinction, we wouldn't need computer misuse law, because computers would only ever be used in the ways intended. The very possibility of bugs and mistakes is what drives a lot of law and a lot of computer law.
So there's many other things I'm interested in talking about, but maybe I want to kind of circle back to the way in which you situated this project too. So maybe spend a little bit more time thinking about how this fits in with like the longer tradition of writing within computer science and law. And so, this is in a way speaks to some of the earlier writing, which I think you helpfully characterize as architecturalist, right? This kind of code as law attitude. But I also wonder how you see this fitting into more recent debates within this community. Where do you kind of position this? How do you imagine this kind of moving the conversation?
Yeah, so in the architecturalist tradition, in some sense, I'm writing about blueprints and understanding how expressing things using language or communication results in changes in things built on the ground or built with software. In terms of another long-running debate, a long set of conversations within computer science and within tech policy, this is really connected to the long back and forth in AI between your symbolic, good old-fashioned AI methods that involve formally correct deductive reasoning and your statistical machine learning style techniques that involve uses of large data to draw statistical conclusions. And so the people who wanted to formalize law, and there's a tradition of this going back longer than I've been alive, have worked within the tradition of creating logically valid systems that can be used to do deductive reasoning about legal propositions. And you get lots of questions about how do you sand the edges off of actual legal doctrines to make them formalizable? What are you capturing? What's the right way to model them? Lots of interesting work there, but it also runs into difficulties because you're always approximating things that lawyers are content to leave open-ended. You need a precise representation for them. And so part of the discussion here is about why language is the crucial element in that, and how the open-ended social negotiations of natural language leave more play in the joints than the kind of formalization you do when you represent things on a computer. And there's a great traditions in STS and in HCI about dealing with those gaps. And what do you do when your system can't represent all of the nuances in the mind of the user who is bringing it to you? What I'm trying to do is I'm zeroing in on the role that language and communication plays in there. How do you map between the natural language the user is using and the formal language the computer's working in? Another thing that you get at here is, though, we have this great shift in AI in the last few years. There's a huge excitement around the success of machine learning methods. And one way of putting that is part of the success for real-world application projects and in law may precisely be that they're not trying to hold to fully formally valid reason, that it will get results that match human intuitions and are sometimes messy in some of the same ways. So towards the end of the book, I'm hoping to have a bit about the use of statistical techniques in thinking about legal problems. A bunch of legal scholars have been doing corpus linguistics where they run queries over very large data sets of natural language tagged examples. And if you use that, you can try to draw a conclusion about what does the phrase carry mean in the context of a statute that prohibits the carrying of firearms under certain circumstances. Does it mean have it on your person, or does it mean have it in your glove compartment of your car? That's a question that feels a lot like some of the modeling debates that people doing machine learning have about what counts as a correct example. How do we know what the ground truth of our labeled examples are? I think there's a lot of interesting work there on the computer science side that would help inform the law side in terms of how to think about what these kinds of queries can and can't tell us.
Yeah, and I definitely want to leave some time for people in the audience to ask some questions, but maybe one last question for you is to ask to say a bit more about how each community can kind of learn from each other given the observations you're making here. So you've already just mentioned one, but I know that you have others, and so yeah, I invite you to maybe reflect on what other things we might have the legal profession learn from what computer scientists and engineers are doing, and the reverse.
So I think the most exciting place where the legal profession can learn from computer science is in the tool chain. That legal drafting is astonishingly primitive compared with programming right now. And everything from the version control to the debugging processes could benefit enormously from thinking about things that software engineering has learned. And given these similarity in drafting tasks, you could imagine so much better tools for things like fitting statutes together that would automatically keep cross-references correct and raise questions of, did you really mean to scope to this paragraph? Don't you mean to scope it to the subparagraph? There are lots of places there where I think thinking of legal drafting as a kind of programming helps you do it better, because computer scientists have learned from horrible, hard-fought experience how to overcome some of these difficulties, especially in collaborative settings. And I think looking the other way, I'm really kind of excited to bring some of these interpretive theory tools over to the computer science side. They're part of a toolkit that I have as a legal scholar that I don't think I realized how informative they were and how broadly applicable until fairly recently. And I think that they actually have, I think they could be quite useful in thinking both about programming language design, but also about expressivity in various interface settings and in various API design too. You can really ask great questions about what you're communicating and who your audiences are.
Thanks, James. So I did mechanics, but I do want to invite folks in the audience to ask some questions.
I think you actually got to some of the question earlier about the tool chain, because I was asking about so the analog of software engineering tools like version control, automated testing, continuous integration for the law. So I guess I wonder more about what that vision would look like.
So this is a whole separate project that probably won't get to be part of this book, but there's an amazing history of legal information technology in computer science terms. So that basically legal publishers invented a reverse index in order to be able to find out what cases cite previous ones. And there's a remarkable incident in the 1930s during the New Deal when agencies were passing regulations right and left, when an agency found itself trying to enforce a regulation that it had actually repealed several months before and hadn't realized because it just didn't have anything collected. So they basically invented a log structured file system in order to keep track of changes to statutes. So the versioning updates, basically statute updates now are published as patches. Congress will say, this section of the United States Code is amended by striking the following words and adding the following words in their place, which is basically a patch on the existing US code. So there's a classic versioning story there. If you look at things like model statutes and how states learn from each other, you often find copying of language from one document to another in parallel. So yeah, I think that there's a lot going on there where understanding the amendment history of something can be very much like tracing back through a series of Git check-ins.
I really love that you started with a philosophy of language interpretive perspective. I think it's really valuable. I guess what I want to ask you, and my observation is that the examples that you gave of how that might apply seem very localized. That is, they refer, I guess, for convenience to kind of small scale parts of systems. I know that that what we seem to be learning from people who do software verification is that it's awfully hard to verify almost any properties of any large actually deployed system of the sort that we kind of worry about. Like, I'm certain you can't verify any properties of the Facebook code base or the others like that. And so I'm curious about how you think about that, given that I think you're very helpfully trying to find some convergence in how we understand meaning in law and how we understand meaning in systems. I'm not sure it's a solved problem in either discipline once you get to scale.
Yeah, and I think the lesson of the book in some respects is if you're hoping for complete perfection from law, it doesn't exist. It doesn't exist in computer science either. And it's a lesson about the variety of ways in which it breaks down, and yet we still build useful systems. The Facebook code base is not fully formally verified, but they use tools to help catch bugs. They verify some very serious parts of it. Other parts rely upon foundations that have had tools run against them. All of these things combine to make software better. It doesn't meet the perfection, and even if it could be, we wouldn't know that we had the right specification. But the disciplines that come from there can help us improve the quality of what we do. So I tend to think that no, we'll never make law into software, and that dealing with real world phenomena means it's going to be approximated and ambiguous and vague in ways that we'll never be able to formalize even locally. But you can learn from how computer scientists approach the task and achieve greater degrees of consensus about what something does and should do than we've been able to achieve with natural language.
Thank you.
Thanks, James and Denny. I think that's all the questions I have in the Q&A tool, but if there are other folks who would like to ask something, please feel free to pose a question or raise your hand, although I'm not sure if I would see that.
Let me say one thing in response to the anonymous attendee asking about testing, among other things, because this is one of the insane things about law, actually, which is the federal courts are prohibited by the Constitution from giving advisory opinions. They can't rule in a case unless there are concrete stakes with parties who actually have something at issue, which means you can't just take a statute and hand it to the courts and say, does this mean what we think it means? They'll say, that's an advisory opinion, we won't give that to you. In other words, you're actually prohibited from testing any statute on the actual hardware it will run on, which is in some respects a crazy way to run a system.
Well, I think we're getting close to time, and maybe the last thing I'll ask James is, and this is sort of building on the response you offered to Danny's question, is, like, I take this to be sort of a way of saying that the reason the law is not going to have the rigor of computer science is because computer science doesn't even have the degree of rigor that you might think, and that there's always going to be this kind of insurmountable gap between kind of the perfection you imagine that's possible from formal language and what's actually achievable in practice. And yet, despite that, right, despite that kind of recognition, there's still an enormous amount to learn from what computer science has been able to do, given these limitations, and that we should encourage the legal profession to try to adopt some of those lessons themselves. And is that sort of a kind of helpful way of summarizing?
That's a pretty good summary. What I may put is, I'd say, don't make invisible the work that makes computers work. So a great example of this would be blockchains. That there's all this excitement about using blockchains and distributed systems to achieve trustless contracting and to have this immutable worldwide ledger that records things in an unerasable, secure way. And people just take that and say, assume that this works and go on about their merry way building systems that will transform the world. When in fact, this is built upon a massive worldwide consensus among the people who sign on a blockchain and enter transactions on it. And they all collectively agree to treat this particular chain and not some other chain as authoritative. And if you don't pay attention to that work, you get into terrible, terrible trouble with 51% attacks and history rewriting attacks and all kinds of other things people have learned when they actually pay attention to the work of stabilizing a blockchain. The same lesson holds more broadly. You don't just treat computers as these perfect boxes. Pay attention to the systems that make them work, because that's often, for legal purposes, the only reliable source of information about how these systems that have important legal consequences actually work.
Well, thank you, James. This was enormously edifying for me. I was really grateful to have a chance to ask you about this project. I don't know the timeline here. When should we expect to see something? I want to give you a chance to kind of advertise the book.
The answer to that very much depends upon the United States' progress in treating coronavirus. As you have seen, I have 2 children home right now with virtual school. The book is proceeding very, very slowly. If all had gone well, I would have turned in a complete manuscript in June 2021. I very much doubt I'm going to make that date. I'm very much hoping by the end of next year to have the draft complete. But 2020, I've learned not to make predictions.
Well, I'll still instruct people to take a look at James's website, which is also characteristically very well designed. And there's a note at the very bottom that he'll occasionally send out some announcements. So for those who've been enjoying this discussion, I hope you'll sign up and continue to follow James's work. But thank you again, James. I will now hand it back over to Dave.